All right, good afternoon, everybody. Thank you for joining us for another segment of What's Up With Us, the real property law section of the California Lawyers Association. I'm Neil Kalin. I'm joined by Ashley Peterson, who's actually waving and smiling, and we have a special guest who we're going to interview a little bit later today. So we will get to our special guest shortly. So let's see, what do we have on our agenda today? Try and change my slide here. There we go. All right. So what's our agenda today? What's up with us? Well, I thought I'd start with, hey, Ashley, what's up with you? What's going on with you now? Anything?
Hi, Neil. I'm just, chugging along, doing the thing, planning my wedding and traveling when I can. You know me, I'm always gone. So
I do know that. Okay, that's good. And we're going to get to our March theme in our next slide. We've got some really interesting cases today. You see them, the Rucker, the Ballinger, the mash and barrel case. And we're going to talk about SB9 that we tried to talk about last month, but we ran out of time. So hopefully we'll have some time. And in between that, we've got our interview. You can see our interview with Sabrina Venskis. Hi, Sabrina. She's there. Wave, Sabrina. You can hear us. Everybody can see you. Okay, that's great. And then we'll talk about, real briefly, we'll talk about our upcoming activities, and hopefully you will join us for the next What's Up With Us. So let's skip ahead, get going today. What's our March theme? Well, I was thinking about March, and I was thinking, well, tonight is the first night of Purim for anybody who, is aware of that. And what happens in Purim? Well, people dress up, people gather together. There's a little noisemaker there. That's the wooden thing. It's called a Gregor. It's a noisemaker. So people make a lot of noise. And according to some teachings, it's the one holiday where you are given permission to drink to excess. So that's Purim for those of you who want to know a little bit about Purim. What else happens in March? Well, St. Patrick's Day, of course. And what do you do in St. Patrick's Day? Well, everybody dresses up. You dress in green, right? You get together with friends, you make a lot of noise, probably in a bar, and there's probably a lot of drinking going on St. Patrick's Day as well. And March also reminded me, well, what just started this past weekend? Of course, the NCAA tournament. What do? You dress up in your college gear, right? With the mascots and the logos and everything else. You go out, whether it's to somebody's house or whether it's to a bar or whether it's to the stadium, you're with a lot of people, you make a lot of noise, and especially if you're in college, probably a lot of drinking too with the NCAA tournament. So I was thinking, what's the theme for March? And what do you think the theme is, Ashley?
Drinking.
Well, I was thinking, guess what? It's springtime. We just sprung ahead. We put our clocks forward, right? All of these things happen in spring. Life, rejuvenation, all that good stuff. Does that have anything to do with our legal topics today? Not really. I just thought it was a nice little introductory way to kind of bring some light to our webinar today.
I am happy about the daylight savings, though. It's nice that it stays lighter past 5 o'clock, but getting up in the morning before 6 is not so good.
It is kind of nice. I agree. I like, hopefully one of these days, California and the rest of the nation will go on one time all year long. Of course, I was reading about.
I don't know if it's the House or the Senate, but they literally just voted on that bill and it passed. So that just happened to try to get rid of daylight savings time.
Wait, national or state?
National.
Yeah, okay. I'm all for it. I think that would be a great thing. Who needs to be changing our clocks, right?
Yeah, the airlines
remind you to change your batteries in your smoke alarms, but
I think the airlines were the biggest lobbyists on that one because they're like the time differences make such a mess of their schedules, I'm sure.
I'm sure it does, yeah. Well, anyways, I hope it happens sooner rather than later. We don't need it anymore. So good. Well, let me start off. That was kind of a nice little introduction. Thank you, by the way, for our listeners today. If any of you have any questions, please, do we want them in the Q&A or the chat tab? Ashley, what's better?
In the chat, if they have questions, would be great, and then I'll keep monitoring those.
Okay, and we'll try to get you an answer to them. So thank you very much. Now we know what to be doing there. All right, so our first case is Rucker versus Winkel. Case decided just last month on February 4th. You've got the site in front of you on the screen. And what happened here? Well, here we have a case. Plaintiff went for a jog to prepare for a half marathon. She was on defendant's property, and lo and behold, there was a homeless encampment on the property. So she had to veer off into the road. Apparently she stayed in the bike lane on the adjoining street, but unfortunately for the plaintiff in this case, she was struck by a vehicle and severely injured. And all these cases always have kind of a sad element to them. That was the one sad element here. Matter of fact, I remember from the case, the plaintiff was out jogging. It was something like midnight, right? So I don't know if the visibility was an issue and contributing factor to how she got hit and injured. So what did she do? She sued the defendant, the property owner, where she happened to be jogging where there was a homeless encampment. And her causes of action include that the property was negligently managed, maintained, and controlled, and that they failed to inspect the premises, because had they done that, there would not have been this encampment. She would have not have had to have veered off in the road. She would not have been injured, or so the claim goes. And the second claim, that the property owner knew or should have known of the dangerous condition and failed to take steps to remedy it. The defendant moved for summary judgment, saying, well, obviously there should be no claim here. What happened at the trial court? The summary judgment basically was based on Civil Code 846, which provides for liability protection, or protection from liability for recreational uses of property. And the plaintiff here said, well, you know what? Jogging is really just a form of hiking. Hiking is specifically mentioned in the statute. Guess what? That was the issue here, right? And the trial court said, well, jogging has many similarities to hiking. And again, hiking is specifically listed as a activity that provides protection for a property owner, right? As a recreational activity. Hiking is specifically a activity that provides for protection. Jogging is I guess the defendant would have said jogging is the equivalent of hiking. Okay. That was dealing with that issue. So the owner was protected. On the encampment issue, the court said, well, it was open. The defendant had no duty to warn because it was open and anybody could have seen it. Therefore, summary judgment for defendant was granted. The plaintiff, of course, appealed. What did the appellate court find? The appellate court find that jogging is akin to hiking, but that it is not hiking. And the appellate court said the trial court did not say that jogging is hiking, that it's akin to hiking. It falls within the same general category. Jogging is a recreational activity, and there were other cases that kind of define recreation as an activity for pleasure or exercise intended to refresh the body or mind by diversion. The plaintiff was not jogging, for example, because she was late to work. She was not jogging because she was running away for something. She was jogging to train for a marathon. That was exercise. The list in Civil Code 846 is illustrative, but not exhaustive. Therefore, the property owner was protected. Appellate court said, we're going to dismiss the liability argument, the premises liability argument, for the same reason. And Ashley, before you comment, and Sabrina, of course, if you have a comment, you're welcome to as well. I just want to say I've kind of been reading up sort of stuff on this on a neighborhood website. And all I can say is, for all of you joggers out there, all of you exercisers, especially female exercisers who are out there alone, make sure you've got some protection. You know, carry mace, have a whistle, have an air horn. Not far from where I live, it's not just people that you have to worry about. There's coyotes that you have to worry about. So make sure you take care. But Ashley, what do you have to think? What do you have to say about the legal aspects of this case?
Yeah, I mean, I'm not surprised how this case came out. I mean, it seems like a stretch to me that a property owner would be responsible for a homeless encampment on the street. I mean, really, the responsible party here is the city, because they're the ones that are supposed to clean up the streets, keep the homeless people in the shelters, and not allow these, you know, tent cities to pop up in neighborhoods. And unfortunately, with COVID and everything, I think that's just been exacerbated in every city. So this one took place in Los Angeles particularly, so that one's one of the major homeless encampment areas in California next to San Francisco. So I'm not surprised how this case turned out. I feel like the city is probably the more responsible party, but probably due to the municipal immunity that they get, they probably couldn't have been sued in this case, would be my guess. But I don't do litigation, so I don't know that for sure. Just my thought.
And, you know, my thought was, I was actually kind of surprised that this case was published, because to me, it was so obvious that the list in Civil Code 846 of activities that provide protection for our property owner was illustrative rather than exhaustive. So it kind of surprised me, because I didn't think there was anything really new or special about this case, but maybe it was a good case just to emphasize what the rule of law is when it comes to recreational activity.
Yeah, I think so.
Okay, great. So let's move on to our next case. And it's Ballinger versus City of Oakland. And I'm going to let Ashley take the lead. I'm just going to start off with a full disclosure here on what's up with us, which is I work for the California Association of Realtors. This is a federal case, and the company that I work for, CAR, we're actually going to be sponsoring, along with others, an amicus brief in this case. So my employer will have some involvement with this case on a petition for writ at the U.S. Supreme Court. But Ashley, why don't you tell us about the substance?
Yeah, so the couple, the Ballingers, were a military couple, and they own a property in Oakland. They were on a military assignment on the East Coast for over a year, and so they leased out their property in Oakland while they were on the East Coast. And the lease was a one-year term, and it expired and then converted to month while they were still on the East Coast. So when their term on the East Coast ended, they wanted to come back and live in their property in Oakland. And under the Oakland Municipal Code, there are just cause eviction ordinances that are in place that require them to terminate for cause if they're going to end a tenant's lease, and the tenant's been there for more than a year. So in this case, they were required to have just cause to terminate, and an owner moving back into the property is one of those just cause reasons, but it's a no fault just cause. So that means that the owners would have to pay relocation assistance to the tenant in addition to giving them the 60-day notice. And under Oakland's rules, Oakland has very strict landlord-tenant rules, if any of you are familiar with that, but they had to pay half of the relocation assistance up front to the tenant, with the other half paid when the tenant vacated. So the total amount that they ended up paying in relocation assistance was $6,582.40 to be able to move back into their property. So the Ballingers didn't like that, and they filed suit against the city, claiming that this relocation assistance ordinance was an unconstitutional taking, an exaction of their property, and an unlawful seizure of their assets. The trial court, federal district court, dismissed those claims off the bat, claiming that the payment of money was not the same as a physical taking, and it wasn't an exaction imposed on property rights. So there's no seizure or taking based on this ordinance. They appealed that district court's decision, and the appellate court affirmed the district court. So they held that private property shall not be taken for public use without just compensation, but regulation of the landlord-tenant relationship is not necessarily a taking. There's a broad, states and cities are given broad bandwidth to basically enact landlord-tenant regulations. And that unfortunately, none of those ordinances have been held to be unconstitutional in any circumstances. So in the Supreme Court case, Yee v. City of Escondido, which was cited in that in the Ballinger case, they held that the transfer of wealth in itself does not convert regulation into a physical invasion. So in order to have a taking, you need a government action that physically takes a property for itself, and it restricts the owner's ability to use that property. So in this case, the Ballingers were not restricted from using their property. They were just forced to pay a fee to the tenants to be able to move back in. So since the relocation fee was not determined to be a taking, it's not an exaction. The exaction requires them giving up property rights in return for a particular government benefit. So there's no trade-off here. And they also brought up the Fourth Amendment seizure claims, and the Fourth Amendment prohibits searches and seizures caused by state action. But in this case, there was the tenants were not in the cooperation with the city of Oakland, so there was no state action and no seizure here. So yeah, I'm not surprised. I'm surprised that they sued over a $6,000 amount of money when I'm sure they probably spent far in excess of that on attorney's fees to take this up to the appellate court. So I think it's pretty solid case law that these city and state landlord-tenant rules are constitutional, and I'm a little surprised that they did take this up to the appellate court to see if they could get a different result.
So I don't know the financial arrangements that were involved, but the plaintiffs were represented by the Pacific Legal Foundation, so that may have had some impact on, you know, whether fees need to be paid. PLF often looks for cases that they think are good cases to bring to the attention of the upper level courts. You know, some of the things that I thought, you know, PLF probably thought was, you know, really good about this case. You know, we're dealing in the Bay Area. We have what appears to be a same-sex couple, right, involved in the Air Force. So, you know, maybe more sympathetic, you know, plaintiff than some others who might have been involved in cases in the past, right? The law was changed after they had already rented their property. They came back. They have a child with them at the time, right? So, geez, you know, who wouldn't want to, you know, let somebody, you know, a couple move back in to their own home, you know, with their child rather than making them, you know, stay out and rent. So there was, you know, factually, there were some factors, right, that may have made this an attractive case to bring forward. I don't know too much about the tenants. I had, you know, read some allegations that they did not even necessarily re-rent in Oakland, and that they were two professionals who were, I think engineers who were probably making decent, you know, money, you know, on their own. So it's like, are these really the kind of people that need to be helped with a regulation such as Oakland enacted? So those are some things, you know, that get involved in the strategies about which cases to bring. I have to tell you, the one thing that I was really kind of surprised about in the appellate opinion, and was that seizure discussion where they basically said there was no state action. I'm like, the state is the one that's mandating the payment. You know, I really couldn't understand that aspect of the opinion, you know, without going into the details, but it just seemed so odd to me for them to say, well, no, you know, it's the tenant. They're private parties. They're not state. They're the ones who are getting the money. So there's no state action involved. That just seemed like such a short shrift way to address that issue. And there may have been other ways to address it.
Well, the ordinance doesn't even require the tenants to use it for relocation purposes. I mean, they can use that money for whatever they want. There's no earmark on their requirement there. So I have a lot of landlord tenant clients who are extremely frustrated with these, you know, tenant relocation assistance requirements, because a lot of times either these tenants move away or they don't really need to use it for relocation assistance, and they're still having to pay it anyway. So Sabrina looked like she might want to say something on this case. You're welcome to chime in.
Take yourself on mute.
You know, I might be better off starting my interview, which I know is next, so that I can give you some context to my comments, because it will be very different than Neil and your Ashley's comments about this case.
Yeah, that's great. That's right. That's why we're so glad to have you with us, Sabrina, because you bring a point of view that we have not had before on what's up with us, and we like to get different points of view. So we're happy to do that. Okay, the last comment I will make, and that, you know, pick up on something that Ashley said, which is the ordinance does not require that the relocation money be used to actually pay for fees in moving or to actually stay in Oakland. But I believe one of the reasons for the ordinance to be adopted was because of the high cost of housing in Oakland. So it's interesting to say one thing in one part of the legislation, the ordinance, and another in the actual reality. So interesting case. As I say, we know that there's going to be a petition for cert with the California Supreme Court. Whether the Supreme Court is inclined to grant cert and how they would react, I have no opinion on whatsoever. All right, so that's good. And Sabrina, you set us up for the next part of our session, which is the interview with you. And you know what, I'm just going to start with a very open-ended question. For those people who are looking, you could see on the screen that Venskis and Associates, you practice, CEQA, California Environmental Quality Act, I think, is that the right words? And you focus on clean air and water air rights. You focus on housing rights. You are a litigator both before judges and before juries. And so why don't you tell us a little bit about your practice and the kinds of cases that you take and the kinds of strategies that you use.
Thanks, Neil. And thanks, Ashley. I'm excited to be here, actually. I don't usually get to talk to strictly real property attorneys. So it's a great opportunity to share another perspective. And I love hearing what I call the other side's perspective as well. So thanks for having me. So Venskis and Associates was started, I won't tell you how long ago, because that would date me, but a while ago. We've had a lot of years behind us. I actually started the practice. We have about 4 attorneys here. It's a very small boutique firm, one paralegal, and we really focus on a real limited area of law. And so we practice environmental and land use law. We also, and I'll tell you what that constitutes in a second. We also practice what we call housing rights law. And so housing rights law is, as we describe it as housing rights attorneys, is bringing cases against landlords that game the rent control system, real estate speculators that come in, buy up buildings, force tenants out, either with harassment or illegal buyouts, things like that. And then with the goal of flipping the property and making a quick profit. So we bring cases against folks like that if they're violating the law and doing what they're doing. And then we also practice government disclosure law. So we will sue government agencies for failing to follow the California Public Records Act or the Brown Act. So all of these 3 areas of law often overlap with each other, especially when it comes to the environmental or especially land use law and housing rights law. There's a lot of overlap there. A lot of times where those areas of law intersect. And so we bring our knowledge of both environmental land use law to bear on some of the cases that we bring for on behalf of tenants or neighborhood associations or homeowners or neighborhood groups. and vice versa when it comes to environmental laws, such as California Environmental Quality Act. For example, we argued in the trial court here in Los Angeles that the city did not consider its housing element when it gave approval to a landlord to, well, I won't call them a landlord, they're actually an investor, developer, to destroy 40 rent stabilized housing units to build another hotel in Hollywood. City gave them approval, exempted the case from CEQA review, saying there was no need to review under CEQA, do any CEQA review for that project because it was, quote, infill. And we argued that in order to use the infill exemption, you have to find that the project is consistent with the general plan of the city. And because the city never even bothered to look at whether or not this is consistent with the housing element, which is arguably the most important element of the general plan, the city erred as a matter of law in exempting the project from CEQA. And the court agreed and overturned that approval. So that's a kind of case where a housing issue, housing rights issue, and environmental and land use law intersect. So that's the kind of law that we do.
So Sabrina, I got a question for you. I had mentioned that in the previous case that Pacific Legal Foundation tends to be very careful in choosing the kind of cases they bring up. But they're a foundation. You're not. You're a business. Venska and Associates is a business. How much attention do you pay to the kinds of plaintiffs that you're going to represent, or even defendants that you represent?
That's a really good question. We pay a lot of attention to that. So there's a couple factors that go into who we will represent. Number one, is this really a public interest issue? Because in our view, we're a public interest firm, but we are a for-profit firm. There's no nonprofit aspect of our firm. So we look at that. We also look at whether or not the client can pay. Now, we do operate on a sliding scale. We have a very low bono fee, for example, for certain types of clients. So we do also look at, can you pay? Because these cases, especially in the environmental law cases and CEQA cases in particular, are extremely risky. In fact, most cases are, there's very few CEQA cases that are brought, number one, compared to how many projects have to undergo CEQA review. But then in addition to that, the number of cases that are even won at the trial court and or appellate level are very, very, a very small percentage. And so we have to really think about, is this a case that we can win because we're operating on a low bono rate? So we do look at that. We also look at the client. Is this a client that really has the greater public interest in mind? So for example, the case that I just was referring to, this housing element case that we challenged, the organization is United Neighbors for Los Angeles, and their mission is to ensure that we preserve affordable housing rather than allowing it to be demolished, destroyed, and new, for example, luxury or market rate housing goes up, because this organization recognizes that preserving existing housing, especially the rent stabilized housing stock, is absolutely required to maintain sort of the diversity of Los Angeles. And so we like that organization, and we think that organization is, is righteous, for lack of a better description. Maybe that's being too lofty there, but that's the kind of thing that goes into our thinking as to who we will represent. And so we have a lot of folks that come to us and ask, will you represent us on this particular small housing project, or will you represent us on this little, environmental Clean Water Act issue? And if it's not big enough and it doesn't look like it's going to have a real, let's say, greater impact beyond that client's particular limited interest, we won't take it, regardless of whether or not there's funding there.
And Sabrina, when you're looking at cases, are these cases the types of things that can get resolved in a few months, or are these cases that take years and years and that go through to an appellate level? What do you find it?
Yeah, so the environmental cases, environmental law cases go pretty quickly because they're bench trials. Usually, I mean, unless we're in federal court on a Clean Water Act case where we have to prove it up, federal court goes a lot faster than state court, in my estimation. So they'll go pretty quickly. The housing rights cases were usually in front of a jury. And so, you know, especially with COVID, most of our cases got pushed out by years. And usually I find those cases from filing to actually a jury trial. If we go all the way to a jury trial, though, usually they settle. That takes about 1.5 years without COVID in my experience. So the cases, the housing rights cases usually don't get appealed because usually there's a damages request and insurance covers a lot of these claims. And so we find that insurance doesn't want to, insurance defense or the insurance carrier doesn't want to appeal a case where a jury has found, you know, as a matter of fact, that this, and as a matter of law, that the perpetrator actually violated the law. And they just don't want to, it's too hard to win on appeals, usually in that regard. But with the environmental law cases, we definitely have had to litigate a lot of appeals. We find that usually those cases are appealed. If the agency loses, they usually are appealed. And I don't know if that's because the agency has taxpayer dollars and they figure that there isn't that cost benefit analysis that is usually taken into account by, you know, a private entity, developer, investor, so on and so forth. Or if it's just a matter of it's easier to win on appeal in environmental law cases because the standard of review is de novo, meaning that the appellate court stands in the shoes of the trial court to determine whether or not the agency violated the law. I don't know, you know, all the factors that go into appeal by the other side. I know that when we lose, we usually appeal if it seems like we think it's a really strong case and it's a question of law that would be valuable in litigating at the Court of Appeals so that we could get hopefully a published decision on it if it goes our way. Obviously, there's been times where we've appealed, we thought it should go our way. And unfortunately, the published case harmed the law that we, at least in our view, that we were trying to uphold or strengthen. So yeah, we do a lot of appellate work in the environmental law context.
Okay, and so when, first of all, I could totally, I guess, you know, feel for you in trying to decide, you know, what cases to bring forward and the risk, right, in bringing a case forward if you get a decision that's adverse to your client, and especially an adverse decision that gets published, right? So with my job, I do a lot of amicus cases that CAR gets involved in, and that's always a factor, which is, you know, great, we hope to influence the decision of the court, we hope to influence it our way, but what happens, you know, what would be the consequence if it doesn't? And that's always kind of a balancing act in our determination as to whether we get involved in a case, and it certainly would have a more direct impact, you know, on your clients on whether to do an appeal. So I can appreciate, you know, that recognition. I did want to ask you a follow-up question. When you're doing these appeals, do you represent your client at the appellate level, or do you farm that out?
Oh, no, we represent them.
You represent them, okay. So next month, we're going to have an appellate specialist on What's Up with Us, and we're going to find out a little bit more about that. I had another question to ask you, but, you know, Ashley, I've been leaving you alone here. Do you have something that you want to ask?
We actually have a question from one of our attendees. So they said, I think Sabrina mentioned representing tenants in cases where a voluntary buyout agreement was improper. Under what circumstances are voluntary buyout agreements unenforceable by the landlord? That's a great question.
Yeah.
That's one I'd want to know the answer to.
Yeah, that is a good question. You know, there's a couple of aspects to buyout agreements in terms of how they're violative of the law. So number one, at least in the city of Los Angeles, and there's other rent stabilization jurisdictions. And by the way, I use the term rent stabilization because there really is no such thing as rent control anymore, except in the context of mobile home parks under the law. So rent stabilization ordinances there do contain, and in some jurisdictions, they contain the requirement that buyout agreements be filed with the government agency. Again, if we're talking about the city of LA, the city of LA Housing Department, and also that it contains certain language in the buyout agreement that the tenant understands that that tenant need not enter into the buyout agreement. They have a certain number of days. It has to be disclosed that they have a certain number of days that they can rescind their acceptance of the agreement. And so we find that some people don't follow that rule. The other thing is we find that with some people, and when I say people, I mean landlords or investors or developers. I mean, sometimes they're not even the property owner. There's someone that has an interest in buying the property, and they will go and they'll knock on doors and say, hey, will you take some money to leave? And they'll keep doing that, even though they're told no by the tenant, to where it becomes harassment. And when it starts falling over the line of harassment and there's no bright line rule there, then it starts meandering into a potential tenant harassment ordinance cause of action. And there are different tenant harassment ordinances in different rent stabilized jurisdictions. There's some in the Bay Area. There's one in Los Angeles that was recently adopted. There's one in West Hollywood. I'm not sure if there's one. I think there's also one in Santa Monica. And so if a property owner or their agent or a potential buyer is, going around and trying to buy out everybody and not taking no for an answer, that could be constituting harassment. And there's penalties, potential attorney's fees, and a cause of action that can be brought by the tenant for harassment in that regard. And the reason why those ordinances have been, unfortunately, had to have been passed, I can tell you from my own experience in having represented tenants for the last, again, I won't say, but it's way over a decade. We've seen this kind of behavior. We've seen this just merciless harassment of tenants, especially by people that are in the business of buying up rent stabilized properties or properties that have low rent paying tenants because mom and pop never raised the rent. And the tenants finally just can't live a peaceful life, and they just decide they're going to voluntarily leave. And these folks that are engaging in this kind of conduct know that, they know human nature. And so this is the game they play. And so the government has had to step in and say, you know what, this kind of thing can't happen. And when you do it, you're going to have to pay a penalty because we want it to stop. So yeah, those are the kind of cases that we will get involved in. Again, they have to be really bad actors. It's not somebody it's not mom and pop going in and not liking a tenant, one particular tenant saying, please, I'll just give you money to leave, like get out of my life. These are people that are in the business. This is their mode of operation, where they'll buy up buildings, and the first thing they'll do is just go in and try to get people to take buyout agreements and not stop trying until they finally succeed in getting everybody out.
Well, thank you. That was a great answer to the question that was raised by the audience. I appreciate a real clarification. When you started off, you talked about, abuses of the system. And I think you provided a real clarification of what you meant by that. We've got to move on. I was going to ask you about, CEQA in the news. It's being used in ways, people probably never even thought about it when CEQA was enacted, right? The big case getting a lot of attention in the city of Berkeley suing UC Berkeley. And I just read something last night that the state legislature basically passed some kind of retroactive law to undo the decision, but we'll have to address that on another time. but it seems like it's an expanding area that your firm is involved in. So thank you, Sabrina, and I hope you stick with us. And I think you're going to have probably some comments on some of our other legal issues as we move on.
I'll stay as long as I can. Thank you.
Okay, great. Thanks, Sabrina. I appreciate it. So we're going to do one more case here, and this is J&A Mash and Barrel versus Superior Court, decided in January. And when I first read this case, or I read the summary of this case, I thought, oh, this is going to be a little 2-minute read for me. It's a kind of a procedural issue. Was there proper service on a partnership? And then I opened up the case and I see it's 33 pages. I'm like, why did I decide that we're going to do this case for our woo-woo? But it really is kind of an interesting case. I'm not going to go through all these facts, but basically what happened here, you had somebody who owned a brewery business on a larger parcel of land, and they had a right of first refusal or a preemptive right to buy if the owner of the larger parcel decided to sell. And lo and behold, the owner of the larger parcel did decide to sell, entered into a contract to sell to actually another tenant on the property in one of the other buildings on the property. And when the brewery business found out about it, they said, well, wait a minute, I want to exercise my preemptive right to buy. They were given a buyout price, but with no backup whatsoever to the price. And they said, well, you know, that's just ridiculous. It's a ludicrous price that you're saying I have to pay to buy, you know, my portion of this parcel. Now, again, this was one portion of a larger parcel. So even the buyout agreement, the preemptive right to buy, had conditions associated with it, contingency that the parcel could be split, a condition about how the price would be set. So there were some factual matters that still needed to be resolved, even once the preemptive right was exercised. So they went from this, you know, really large price, the owner, down to a smaller price that was allegedly based on some information. And then as discovery happened, they realized, well, that even wasn't based on reality, right? So the seller went from asking for $2.5 million for the buyout to $1.268 million, you know, and if you looked at the later price, the owner said, well, I'm going to value these separate kind of uses of the property separately. And they exceeded, you know, the value of what was actually, you know, stated. So a lot of problems, a lot of dissension, of course. The tenant said, well, the only reason I was given these high prices was they were trying to discourage me from exercising my preemptive right to buy. What caught my eye in this case was the landlord was what was called Tower Theater Properties. But then maybe through some change in ownership, the actual owner of the property was Tower Theater Productions, a general partnership. And then there was service on the party who could be served for the TTP, but not necessarily on the general partnership. And then the case goes through and says, well, wait a minute, if the first entity was a partner in the later entity, then that service was okay. And if the agent for service of process was a partner in the later entity, then that's okay. And then the court went on to say, and even if not, which was kind of interesting, even if not, well, guess what? There was substantial compliance with the service requirements anyway. So kind of an interesting addressing of the case with Liz pendants and some of the specifics dealing with Liz pendants. There was also issues of bad faith. As I say, the owner of the original parcel, the landlord, kept changing the amounts that they were asking the tenant to pay. And so it was more, this is really more than just a simple case of service. Service may have been what was the focus of the appeal. But there's a lot of interesting facts here. And Ashley, what do you say?
Yeah, J&A ended up getting their legal fees paid on appeal when they reversed it. So clearly TTP was in the wrong when I found this case really interesting because I deal with rights of first refusal quite a bit with clients, and I draft them as well. And there are some that are drafted really poorly, but this one was pretty clear on what needed to happen. And TTP did not give them the proper notice with all the information required to allow them to exercise their option. So they had their attorney send several letters that were just, we have a buyer and are you exercising your right or not, and then trying to get them to sign a waiver of their rights and a subordination agreement and all these things that they're like, we can't even sign these because we don't know what the buyout is actually for. So yeah, it seems like clearly there was some wrongdoing and bad faith on TTP's part because they probably found a buyer who could buy it for a lot more than what they could potentially sell it for. So yeah, I found it interesting, and it reminds me how important it is in drafting those rights of first refusal, how clear you need to be and what has to happen to exercise the option and when, because I have seen some where there's an unlimited time frame and these people the sellers want to sell their property and they can't because the buyers don't exercise their options or don't want to, so there's no time limit and they can just go indefinitely.
When I was reading through the case, it was kind of interesting to me thinking about what was the strategy of TTP, right, in going through that sort of fictitious process. And maybe it kind of reminded me when Sabrina was talking about, a landlord or a property owner that's really acting in bad faith, hoping that the tenant will just go away, right? Maybe if we just beat them down enough, they'll just go away. Obviously, having the potential right to buy this property was important enough for this tenant to stick with it.
Yeah, I mean, it sounds to me like TTP's attorney screwed this up because, they didn't come to the brewery with the notice of the sale until 3 days before close of escrow. And I can guarantee you that escrow was longer than 3 days. So if that attorney did not read the lease agreement for the existing tenants to see if that's even in the leases, that's the first thing I do when I do any kind of property sales for clients. So that seemed like a big, what's the daisy to me.
Good advice, Ashley. That's why we have you here on What's Up with us. I'm going to skip over. We'll just quickly go over Senate Bill 9 that was passed last year, effective January of this year. But I want to go back to our first case. I was saying, I was kind of surprised it was published. Remember that case about the jogger? And thinking about it right now, I was thinking, well, I picked up on something you said, right? There's such a homeless problem in LA in particular, but not just LA, all over California. And maybe one of the reasons the court said we're going to publish this decision is because it's addressing the issue. Are we going to hold a property owner liable for a homeless encampment that is on that property owner's property that the property owner may not be able to do anything about, quite honestly, right? So that could be a reason why the court thought it was important to publish that first case.
I think that's a good point. And I know homeowners who have this similar issue in San Diego and they can't get the police or the city to do anything about it. So there's literally nothing these homeowners can do to prevent this from happening on their property.
All right, so real quickly, just want to mention SB 9. So this is the case that some people say is the destruction of single-family zoning in California. It's not really quite that extreme. Some people say, well, single-family zoning, if you're a single-family zone property, every single property now can be turned into 2 units and can be split into 2, so you can find 4 units where there was once 1. And it's really not that extreme either. Like any other piece of legislation, you can see that there's trade-offs involved that the legislature made. So what are the 2 core portions of Senate Bill 9? Well, first of all, that there needs to be ministerial approval at the local level to create 2 units on a lot zone for single-family residential property. Is it everywhere in the state? No, what are defined as urban areas only. Certain types of housing cannot be demolished. Low-income housing, rent control housing, housing that was rented in the last 3 years, which I don't totally get, because if the point is to increase housing, so what if it was rented in the last 3 years? If it's not rented now and there's going to be 2 units instead of 1, doesn't that further the purpose of SB 9? So again, a lot of things go into the mix, right, in creating legislation. Won't allow you to do it if you remove the property from the rental rolls under the Ellis Act in the last 15 years, right? Are there certain things that the city can require? Yeah, they can have certain minimums, but they have to allow at least 800 square feet for each unit. If there's an existing structure, right, and then a second unit is going to be built, you cannot require a change in the setbacks from the existing structure. So I know where I live, my house is pretty far back from the street, but some of the houses are really close to the street and they might have a really big backyard. So maybe somebody could say, you know what, I'm going to put a second unit in my really big backyard. And maybe the current zoning would say, no, all units have to be whatever, 30 feet from the street, 50 feet from the street, whatever it is. Guess what? The city, you cannot do that for an existing structure that's there. And there can be no parking requirement that's more restrictive than, get this, in one off-street parking, right? So basically you can't say than one off-street, right, per unit. So, all right, not too hard, but if you're close to public transportation, they cannot have really a parking requirement at all. So interesting thing, if you look down, it says added rules right before the government code section. As part of the requirement of this law, the city must prohibit, right? You cannot have short-term rentals for these properties where they've been split or where you put a second unit on a particular lot. Again, that's the trade-off, right, that's being met, which is homeowners, as a general rule from what I hear out in the field, don't really like short-term units. They think these people who are not invested in the community, come, have parties, make noise, right? That's the stereotype, right? And homeowners aren't really crazy in single-family residential neighborhoods of that kind of use. So here to say, well, great, homeowner, you can put 2 units on a lot, but you're not going to be able to use either one for a short-term rental. The second part of SB 9 is splitting a lot into 2 parcels. A lot of the same rules and restrictions as with creating 2 units on a lot. Notice the same thing. There cannot be any short-term rentals if you're splitting a property into 2 parcels. And if you're going to do that lot split, guess what? The applicant has to agree to own or occupy for 3 years as a principal residence. So a lot of trade-offs, right? What was, I think, the purpose of SB 9? To increase the housing stock in California. Hopefully people will build more units, may split and build more units, right? But the legislature recognized, certain trade-offs. Look at some of the things that are exempt. Prime farmland. So it's like, I look at this like prime farmland. Boy, there's plenty of room for additional houses on farmland. But I'm guessing, the whole central part of the state said, yeah, we don't know that we really want that, right? So that could have been some of the involvement. Some things make sense. Do you want additional units in a very high fire hazard severity area, right? Probably no. Do you want additional units in earthquake fault zones or in conservation land, right? So you can look here, you can see some of the other exemptions. Notice though at the bottom, while there may be required ministerial approval for these things, the Coastal Commission still has jurisdiction and their rules are going to apply. That's all I have to say about that. Ashley, I don't know if you want to comment, if we'll go into what's going on with real property.
No, I think you summarized that well.
Okay, great. So here's what's going on. If you want to see some webinars, hey, good webinar tonight from 5 to 6 p.m. on global commercial leasing by a former real property XCOM member is leading that. That's Pam Woodson, right?
It's Joanne's series, but I think Pam is doing this one particularly. Yeah. And this one's, so she has a bunch of them in the series. This one's specifically on Spain, so commercial leasing in Spain and all the differences compared to California. So definitely tune in. They're really informative seminars, really interesting to hear about how other countries do commercial leasing. So definitely tune in if you can.
And the other two that I selected, they're reruns. You know, I just thought they might be of interest to our audience. I actually attended the one that's being replayed on March 29th. I attended that one in person. It was really interesting to hear, you know, some of my colleagues talk, who I know are friends, but they're on opposite sides of the case. And how does that, you know, affect them? You want to do a webinar, you see who to contact there, Nancy Goldstein. Coming up, CLA's Legislative Day. Ashley, I'm going to let you talk about the Health and Wellness Retreat in a minute, but we'd love to get people to write articles for our monthly e-news or for our Greater Real Property Journal. You can see how to do that. Ashley, tell us about the Health and Wellness Retreat.
Yeah, we're just about a month away from the Health and Wellness Retreat. We hope that for those of you that don't know, you'll join us. This is a retreat. It's only basically a day and an evening. So Friday evening, you'll have a welcome reception with a happy hour and s'mores by the campfire. Saturday, we'll have a breakfast keynote speaker on stress and burnout. And we'll have some concurrent seminars on some of the specialty credits for MCLEs, if you're looking for those, as well as 2 real property substantive law seminars, and a lunch keynote from a fitness professional who'll talk about changing habits for positive things in your life. And then we'll have a great afternoon hike in the mountains and evening beer and wine tasting and dinner on the Lake Tahoe ferry. So it's at the Ritz-Carlton in Lake Tahoe. We have an amazing rate on the rooms. I think it's $261 a night. So those room rates are only locked in for the rest of this month. So if you do not book before the end of this month, you will lose out on that amazing deal for a room at the Ritz-Carlton. So please sign up. We'd love to see you. It's a great event to bring your family to. I know Neil's bringing his family. And I'm bringing my fiance, so it'll be a good time.
And my son was telling me, he said, hey, there's going to be snow in the mountains until June this year. I don't know how. There's no rain in Southern California, but I guess they got a lot of snow up there in the mountains. So something else to think about. So
well, we might have to dress warm on the hike.
Sounds good. Thank you very much, Ashley. I hope everybody can join us. Again, if you've got comments, questions, suggestions, thank you. Beth put the registration link in the chat box. We now are regularly posting our What's Up With Us. So if you like listening to these things, you can go in. There's the links on your screen, and you can find us on YouTube, on the CLA's Real Property, I guess, page on YouTube. And we hope to see you next month. I said we're going to have an appellate specialist join us next month. So for a little different take on real property law. So thanks, everybody.
Thanks, Neil. Good to see everybody.
Bye, Ashley. Bye, everybody.